100 years ago, a doctor at a hospital in Minnesota treated a child for scarlet fever. The patient's mother asked whether she and her husband, the patient's father, could visit their daughter safely. The doctor allegedly assured them that yes, they could, and they did. As a result, the parents said they contracted scarlet fever. The father sued the doctor for negligence. The doctor argued that the allegations, even if true, did not amount to a valid claim. The Supreme Court of Minnesota called the case a novel one. But the court applied long-standing principles of tort law and concluded that all the necessary elements of a cause of action based on negligence are present. We're talking now about the novel coronavirus, but the law about the negligent spreading of contagious diseases is reasonably settled. Here's how the Pennsylvania Supreme Court put it in 1937. If a man contracted smallpox through another's negligence, he would have a right of action. To be stricken with disease through another's negligence is no different from being struck with an automobile. The basic elements of any negligence case, whether involving cars or contagion, are a duty, a breach of that duty, causation, and injury. We all owe a duty of reasonable care, either to the world at large or at least to those within a foreseeable orbit of risk of harm, as the Pennsylvania Supreme Court put it, in an opinion holding that doctors owe a duty to third parties who suffer harm when doctors fail to advise patients who've been exposed to a communicable disease about the risk of infecting others. For example, in a Texas case, when an employer was trying to treat an employee for smallpox but allowed the employee to escape from the treatment facility, the employer was liable to other people who later contracted smallpox from the employee. To decide whether a defendant has breached the duty of care, one must consider the reasonableness of the defendant's conduct. One way to do so is through Judge Learned Hand's controversial formula, holding that a defendant has breached the duty of care in failing to adopt a certain precaution if the burden of adopting it is less significant than the combination of the probability of harm and the magnitude of the resulting loss. In other words, Judge Hand wrote, the defendant is negligent if B is less than PL. Regardless of whether we apply the Learned Hand formula, a common precaution we can all agree on during the current pandemic is to use Learned Hand sanitizer. Here are some examples of classic cases in which defendants have breached the duty of care. In New Hampshire, a hospital assigned a student nurse to take care of a patient with diphtheria, but didn't warn the nurse of the danger of contagion. When the nurse contracted the disease from the patient, the hospital was liable to her. In Wisconsin, a couple hired a maid without telling her that their daughter had typhoid fever. After a couple of days, the mother mentioned the illness to the maid, but assured her that it was not contagious, and so the maid kept working. When the maid suffered her own attack of typhoid fever, though, she was able to hold the father liable for failing to inform her properly about the daughter's condition. In North Carolina, a husband was liable to his wife for failing to take steps to avoid infecting her with a disease of a foul and loathsome character. In that case, the foul and loathsome disease was gonorrhea, but the same principles would apply to COVID-19. What about the element of causation? In a 19th century case, the plaintiff sued a landlord for renting out a tenement that the landlord knew had been tainted with smallpox without warning the plaintiff or his family of 10, or taking any precautions such as ventilating the tenement or cleaning it with carbolic acid. The family moved in on May 5, 1871, and by the end of June, the whole family had smallpox. When the plaintiff sued, the landlord protested that causation could not be proved because the source from which and the manner in which contagion is communicated is too uncertain and insusceptible of proof. But the Supreme Judicial Court of Massachusetts held that normal principles of causation applied. The defendant's negligence was an adequate cause of the injury. He cannot escape the consequences of his negligence upon the plea that the connection between cause and effect cannot be proved beyond possibility of doubt. The first negligence lawsuit about the novel coronavirus raises an interesting issue about the last element of negligence, injury. This past February, Eva and Ronald Weisberger, a Florida couple, set out for a long cruise from San Francisco. But after an outbreak of over 20 COVID-19 cases on the ship returned to California, where all the passengers were taken to land and put in quarantine. The Weisbergers sued Princess Cruise Lines, alleging that the company had been aware of a previous outbreak on the same ship and yet had failed to take proper precautions. The Weisbergers had not actually contracted the virus themselves, however. Instead, they alleged that they were at risk of immediate physical injury proximately caused by the defendant's negligence. Historically, courts have allowed recovery for fear of future injuries only if the injuries are more than 50% likely to happen. Recently, however, many courts have become willing to treat the risk of a future injury as an actual present injury, thus allowing plaintiffs like the Weisbergers to win. It's hard to predict the future of injuries or of litigation, but it is safe to predict that Weisberger versus Princess Cruise Lines will be only the first of many lawsuits that stem from exposure to the novel coronavirus, but that rely on traditional tort principles of negligence. Thank you.